Good morning and welcome to our latest webinar with Nick Davis, our Senior Tax Dispute Consultant. The webinar today will be on tactical use of the Tax Tribunal and ADR. Thank you, Nick. Over to you.
Thanks very much, Sarah, and good morning, everybody. So firstly, just to explain what I do, as it says, I'm a Senior Tax Dispute Consultant. So I am a tax person, and I've been a tax person for very many years, probably longer than some of you have been alive, because in May it was 47 years. But I'm not doing the sort of things that tax people generally do. So I certainly don't do tax returns for anybody. In fact, I've even been known to be late with my own. How dreadful is that? And we don't do any tax planning either as a tax dispute consultant. All we do is represent clients in any dispute, investigation or inquiry with HMRC across any type of tax. So I suppose what we call the top end is fraud. So we deal with an awful lot of tax fraud, both cases where tax fraud has actually taken place, or indeed in cases where HMRC are alleging that it has taken place, and in fact the taxpayer is innocent. So that's quite a large part of what I do. I also advise on any sort of inquiry or investigation by any area of HMRC, no matter how large or small. So, you know, some of the cases are extremely significant, very often involving quite well-known people who basically say, well, I don't care how much I've got to pay, but please keep my name out of the papers. I don't want to be the next Jimmy Carr. And as a part of my role, I'm also a litigator, and that's really what the session this morning is about. So what I mean by I'm a litigator, I represent clients in the first tier tax tribunal, and I also work alongside counsel in the higher courts in which I can't be heard. So we do have to have a barrister for those cases. And I suppose really the reason for this session is that I'm very, very used to working in the tax tribunal. It's a very archaic environment, but speaking to other advisors who maybe don't have the experience of it, I do get the impression that there's a bit of mystique and almost awareness about it. And there's also a perception that going to tribunal will be prohibitively expensive unless you've got very deep pockets. So, you know, I'm here to talk about what it's like going to tribunal, but also to talk about uses of the tribunal as a tactic or as a strategy that very often don't even involve progressing as far as a hearing. And in fact, these days, since alternative dispute resolution was introduced and has matured in the positive way that it has, most cases that we list into tribunal are with no expectation whatsoever that it will proceed as far as a hearing. So it's a very, very useful tool or weapon, if you like, in the armory of a tax dispute consultant, and it is by no means as expensive as people think. So in terms of what we're going to talk about today, well, obviously, you know, the tax tribunal, what it is and how it works, but also ADR, alternative dispute resolution. I'll call it ADR from now on, and how that works and how it can be used very successfully and very positively to resolve difficult or long-running cases. We'll also talk about tribunal if a case does actually proceed as far as a hearing, which, you know, as I mentioned, from our point of view, is far less than it has been in previous years. and probably most importantly, the strategic and tactical use of the tax tribunal. It does say any questions at the bottom. Unfortunately, this webinar is being recorded, so we've not got a live audience. But what I will say is if following this session you do have any questions, please just get in touch with your usual ETC contacts and we'll be very happy to answer them. So to crack on, the tax tribunal. We talk about the tax tribunal, but there are actually two. There is the first tier tax tribunal, and that's the first port of call, basically, for any appeal. If you have an appealable tax decision, you can appeal it into the first tier tax tribunal. The case will be heard and a decision will be made. But that doesn't have to be the end of the road. Because once you're into the first tier tribunal, you're into the courts and justice system, and decisions can be appealed. So in the first instance, if you get a decision in the first tier tribunal that you don't like, you can appeal it to the upper tribunal, but only on a matter of law. So if we consider that the judge in the first tier has misinterpreted the law or made a flawed judgment based upon the law, we can go to the upper tribunal. So the tribunal is governed by legislation, and I've just spotted the first typo on the slide. So you've got rules for the first tier tribunal and rules for the upper tier tribunal. I've put the legislation up there on the slide. They're surprisingly readable, actually. So really, it's just to understand what the procedures of the two different tribunals are. But Rule 2, which appears in both sets of rules, is the pertinent one. The overriding objective of a tax tribunal is to deal with the case fairly and justly. Now, what this means is that you will always get a good hearing in a tax tribunal, full stop. It's not part of HM Revenue and Customs. It's entirely separate. And we very often have situations where HMRC are very robustly and publicly criticised by a judge for the parlous manner in which they've run an investigation. Very often a judge will say, well, I don't think this matter should have even come before me. HMRC haven't done their job properly. They haven't investigated properly. So if you ever do find yourself in a situation of appearing in a tax tribunal, you can be absolutely confident that you will be treated fairly and justly. So what sort of appeals can the first tier tribunal hear? Well, substantive appeals relating to a dispute between HMRC and the taxpayer. And really, they tend to fall into two separate and very distinct categories. Quite simply, any dispute over tax generally comes down to the question of whether or not something is taxable on a taxpayer, or whether or not something is allowable as an expense or a relief or an exemption. And that comes down to an interpretation of the legislation that covers that particular aspect of taxation. So that's what we're doing. HMRC have made a decision, whether that be a closure notice or the raising of assessments. And if we consider that that they've come to incorrect conclusions, then we can appeal that to the first tier tax tribunal. It's also there for a taxpayer to make an application for a late appeal to be accepted. Now, generally, there's an appeal window. Certainly, if HMRC raise an assessment, whatever that might be, corporation tax or any of them really, you've got a 30-day, a statutory 30-day time limit in which to make an appeal. And sometimes, for all sorts of reasons, the appeal doesn't happen in time. So you can make an application to HMRC to accept a late appeal, but they are only able to do so if they, and by they I mean the particular caseworker, is persuaded that there was a reasonable excuse for the appeal being made late. Now, HMRC caseworkers, being as they are, they will tend to say, well, I don't consider you had a reasonable excuse, so I'm not going to accept the late appeal. Which at that point would mean, well, you know, it might very well be that HMRC's assessment is wrong, and you're not going to get justice because you didn't manage to get your appeal in within the 30 days. Fortunately, if HMRC take that stance, we can apply to tribunal for a late appeal to be accepted. And tribunal take a very different view. For one thing, they don't have to simply consider whether there was a reasonable excuse. They can consider other factors as well. And those factors include things like, well, what would the respective prejudice be on both HMRC and the taxpayer of either allowing or not allowing the late appeal? Well, the prejudice for HMRC is quite simply that by allowing the appeal to proceed, any tax that is due is going to be paid later. But I don't see that as a particular issue because, of course, they'll be charging interest on it. The prejudice on the taxpayer is losing the ability to actually make their appeal and to put forward their case. So very often the tribunal finds in favour of the taxpayer and allows the late appeal on the basis that, well, it would unfairly prejudice the taxpayer to a far greater extent than it would HMRC. HMRC can also make applications to HMRC to issue a Schedule 36 notice. Now, I'm sure we all know what Schedule 36 notices are, but it's effectively a legal information notice that HMRC provide to a taxpayer in respect of an investigation, or more personally in this case, to a third party where they want information relating to their investigation. It's a legal notice and you have to comply with it if you receive one. But third-party notices are a little bit different. So by a third-party notice, this might be that they want invoices from one of your customers or one of your suppliers, and you might not necessarily hold copies of them, so they want to go to them. And of course, that could bring with it reputational damage to you if HMRC are asking, you know, your customers for information relating to a tax investigation into you. So the rule of thumb for a third-party information notice, generally, and there are some exclusions to this, but generally, HMRC can only issue a third-party Schedule 36 notice with the written agreement of the taxpayer. And very often we might be minded not to give that agreement for perfectly good reasons of confidentiality and protection of reputation. But in those cases, HMRC can go to tribunal and ask tribunal to make an order to issue a third-party notice. But they've got to convince tribunal that, you know, the matter is of sufficient importance, and also that that information really is reasonably and proportionally needed for the purposes of their investigation. In certain serious cases, they can simply go to tribunal in secret to obtain one of those notices, and that's if they can persuade tribunal that if the secrecy was removed, there's a realistic chance of the documentation being destroyed, But by and large, they do have to go to tribunal and you know, make a request for the notice. And of course, we can make our representations the other way to try and prevent that notice being issued. The next one is a really useful one for us. So I guess anybody that's dealt with HMRC investigations will recognise the situation where the caseworker simply refuses to close down their investigation. So they ask questions and we answer those questions, and it's not what they want to hear. So they think of more questions to ask and we answer those. So then they come back with more questions, and I term that getting us onto the carousel. So, basically they want to obtain some sort of tax yield and penalty from that case. So they've set their minds on that and they've decided that they're almost going to starve the taxpayer into submission. So, they're thinking, if I keep this case open and keep asking more and more and more and more questions, in the end, the taxpayer is going to get sick of paying professional fees to deal with it and just accept what I'm saying and pay the tax. We don't allow that. And we also recognise very early on if we've got a taxpayer that's going down that road. So they're asking for things that we don't think they reasonably actually need, or they're ignoring evidence that we've put forwards. And it gets to the point where, as far as we're concerned, they've asked all the questions they need to ask to be able to take a decision. And they don't need to carry on asking for more and more stuff that they probably don't need anyway. They need to take a decision. And in those cases, we can apply to tribunal for a closure notice. And that is very quick, easy, and inexpensive to do. Very inexpensive and quick to do. So effectively, we make an application to tribunal saying, look, our client has been fully cooperative with HMRC. We've answered all of their questions. We've provided them with everything they need to make their decision. So in our view, they now need to make their decision. Please, will you issue a closure note, an order to them to issue a closure notice? So make your decision now. Now, tribunal will issue a closure notice order by default unless HMRC can come up with very, very good reasons why they shouldn't. So if you get stuck with an awkward caseworker who's refusing to close a case, just be aware that's there and it's really useful, really useful. And the last application that we can make there is a hardship application, and this is done in VAT cases. So where there is VAT that's in dispute and HMRC have assessed it, the postponement regime for VAT is slightly different than it is for direct taxes. So generally, the rule is that even though it's in dispute, you have to have paid all of the VAT before tribunal will hear the case. But you can make a hardship application, which is basically saying to tribunal, well, look, this VAT is in dispute and it would severely inconvenience our client financially if they had to pay it up front. So it's effectively tribunal agreeing to postpone payment of the VAT until after the case has eventually been decided. So that's something that we go through in the vast majority of VAT cases that we deal with in the tribunal. So the jurisdiction that the first tier tribunal has got, so it can hear and determine tax appeals. So any dispute over tax, but it doesn't have, and this is important to note, it's an important distinction, it doesn't have what is known as general supervisory jurisdiction. So in other words, it's not able to make a ruling on how badly an HMRC officer has behaved. although they will certainly comment on that, or, whether HMRC have been wrong in refusing to exercise discretionary powers. So essentially, if HMRC have behaved badly, the tax tribunal aren't going to be particularly interested in that. They're only going to be interested in the tax legislation and whether it has been interpreted correctly. So if HMRC are making in my view, willfully making the wrong decision out of sheer bloody mindedness, we can challenge that on public law grounds by applying for a judicial review. We don't want to be doing that too often because it is horrendously expensive, but it is there and we do occasionally use it. So really a judicial review, it may be pursued in circumstances of illegality. For example, if we think HMRC has acted beyond its powers or has abused its powers. So they've made an irrational decision that any sensible person would see as being completely irrational. So in other words, they make a decision that is so unreasonable that no reasonable authority in its position could have made such a decision. And where there's been procedural impropriety, for instance, where they failed to follow the relevant statutory procedure, or they failed to give reasons for a decision, or they failed to consider representations, or they failed to observe the rules of natural justice. So it's where the tax legislation is the issue. It is the way that HMRC have operated, and judicial review is there as a potential remedy for that. So the precedence value of tribunal decisions. So, as I've said, the first tier tribunal is, sometimes the first step, and decisions of the first tier can be appealed to the upper tier and then up into the higher courts. So a decision by a judge in the first tier tribunal is not a binding decision. So, just because a first tier judge has said, no, in these situations, that is not taxable on the taxpayer in the way that HMRC have sought to tax it. Yes, we've got the win for our clients, but that isn't binding in respect of other cases. Other first tier judges don't have to accept that ruling and can make their own decision. Instead, it's what's known as a persuasive authority. So a judge in a future case certainly has to consider it, but they can come to a different conclusion themselves, although they do have to say why their conclusion differs. The upper tier, that's a little bit different because their decisions are binding but on the first tier judges. So, if there's been a decision where a matter's been appealed to the upper tribunal, first tier judges are absolutely bound by that. Although upper tier judges are bound by the decisions of other upper tier judges, again, they can differ and come up with their own interpretation of the law. The upper tier is bound by the higher tax courts, which is the Court of Appeal and the Supreme Court, but not by decisions in the High Court. And that's simply because the High Court is not a specialist tax court. So upper tier judges can make their own decisions on those. So the taxes that the tribunal, the first tier tribunal, can hear appeals on is all direct taxes for sure, and I'm not going to read those out. That's just a list of them. There's actually one not included on there because it's not a tax, but national minimum wage. They can hear, no, sorry, not national minimum wage. So although that is administered by HMRC, of course, it is not a tax. It's actually the BEIS, which is the department that collects underpayments of national minimum wage and seeks to distribute them and makes the rulings on it. So although it's administered by HMRC, we do sometimes pursue appeals in respect of national minimum wage, usually on behalf of an employer, but that's through the employment tribunals, not the tax tribunals. And there's a list of all the indirect taxes. And I think over the years, I've probably dealt with most of those as well. There's a couple there I haven't. I've never done air passenger duty and I've never done alcoholic liquor duties, but I think, and I've not done climate change levy, but I've dealt with all of the others in first tier tribunal at different times. So, there's a very broad range of matters that can be heard by the tribunal. So in terms of listing a case into tribunal, so in the first tier tribunal, there are 4 categories, one of which your case will be designated as, and this will be designated by a judge. So they receive your appeal when you first list the case into tribunal, and they consider which category to put it into. So the first category is very straightforward. It's default paper, it's known as. And what happens there is we simply, both sides, provide the documentation and the correspondence and everything else to the tribunal. There won't be a hearing at all. The judge will simply read the correspondence and they will take their decision based upon that. It will usually be on a very self-contained matter, straightforward and with very little tax at stake. So whether or not an expense is allowable or something like that, that's the sort of case you'll see go into default paper. So actually the cost of the taxpayer are very low indeed because nobody's going to represent them in the tribunal. So you've then got basic, and again, these tend to be the more simple and straightforward cases, but you do actually get the opportunity to go in and present your case to a judge. But the judge will have read the case quite thoroughly beforehand. So effectively, you'll go in and maybe each side will spend an hour or so making the representations. The judge will decide the case based on those representations, and they will usually immediately issue their decision. But the vast majority of cases are within the standard category, and really these are the judgments that you probably read in Simon's tax cases or whatever you use, or when they're reported by Accountancy Age or Accounting Web or whoever. So that's the vast majority of cases. And finally, and importantly, we've got the complex category. And this is where the case is incredibly complicated. It's certainly going to take more than a day. The longest I've had is 10 days for a case under the complex category. There's going to be various different witnesses that are going to be called. There is a huge amount of correspondence and documentation to consider, and that's the complex category. Now, the importance of that is generally in the first tier tribunal, no costs are awarded against the losers of a case. So, yes, okay, you're paying your professional advisor to represent you, but if you lose, you're not going to be hit with an order for HMRC's costs, which of course is great. That's not the case with the complex category. So in those cases, because, quite simply the cost of those hearings is so high, in terms of HMRC manpower and the preparation they have to put into such a complex hearing, the judge can make a costs award against the loser. So they have to pay the winners professional fees and other costs. But if we do have a case allocated to that category, we can ask HMRC to agree to opt out of the cost regime. And more often than not, they will. So we do, de-risk it from the taxpayer's point of view if we get that opt out. The upper tribunal is completely different because in those cases, costs are always at stake. So that's an added risk. So, you're convinced that your case is right. You've gone to the first tier tribunal. Unfortunately, and it can be quite simply because the judge has got out of bed on the wrong side or has had a bad day, but the decision goes against you. And you can appeal it to the upper tier tribunal, but just be aware you have to be very, very sure of your case, because if you lose in the upper tier, you're not only paying the tax and penalties and interest, you're also quite likely to be ordered to pay HMRC's costs. So that's certainly an issue to be aware of there. But I did mention earlier, these days, most of the time when we list a case into tribunal, we don't expect it to go to a hearing. And this is because we now have the ability to make an application for a case to go to ADR instead and be mediated. And we actually recommend to the client that we do this in every case where we are able to make an application for ADR. Indeed, it is strongly encouraged by tribunal, and it's actually within the tribunal rules. They state that before proceeding to a hearing, both parties must consider whether the case is appropriate for ADR. Obvious reason for that, the tribunal at the moment has a huge backlog. It's overwhelmed, mostly by appeals against HMRC withdrawing R&D relief. Actually, that creates an enormous logjam. So, the more cases that can be settled without a hearing, the better. But we do have to usually list a case into tribunal to get access to ADR. Excuse me. Just as a bit of a side on that, in most of the courts and justice system, so all of the non-tax courts, it is now the case where mediation has become necessary. And the court actually requires you to have been to mediation where appropriate before a case proceeds to a hearing. It's not a requirement in tax cases, but I'm going to say yet, because that's the way the court system is going. And I think at some point in the future, all cases will have to go through mediation through ADR before they're allowed to progress to a tribunal hearing. So it certainly saves on time and costs. An ADR meeting, a mediated meeting with the caseworker and typically their line manager, it'll last no more than a day. And it's also a very informal and relaxed atmosphere as well. Sadly, since the pandemic, virtually all of the ADR meetings have taken place via Teams. And it kind of works, but I don't like it. I prefer them to be face to face, and I prefer to be able to actually look into the eyes and see the body language of the HMRC caseworker, because it can guide us in the way that we present our case. But happily, recently, we have had a couple that have indeed been face to face, and I welcome that. And we got very successful outcomes in both of those. So, at least now, the mediation team is once again prepared to come out on the road. In fact, we had a very successful one earlier this year in the ETC offices. Great case, and at the end of the day, HMRC withdrew from their position entirely, so we got the 100% win without having to go anywhere near a courtroom. So, as I say, when we apply for ADR, and both sides have got to agree to go into ADR, um, but it's very rare that HMRC refuse. Um, the case is already listed into tribunal. So what happens is tribunal puts a stay on tribunal proceedings um, initially for 160 days to allow the mediation to take place. Discussions within the ADR meeting are without prejudice, so they are not on the record. So what that means is it's a safe environment um, to discuss really and explore how either side might be able to move towards the other to bring the case to a settlement. But you're not committing yourself to something in ADR necessarily. It's without prejudice, so you can suggest a position, and HMRC are unable to accept that as or treat that as being set in stone. You can also retreat from that position if HMRC aren't moving towards you. What I will say is the HMRC mediators these days are very well trained. And yes, the elephant in the room is that they are HMRC employees, but and we'll come on to this in a little while, they are very, very even handed in terms of how they mediate the cases. Not everything can be listed into ADR, unfortunately. So certainly you can't go to ADR with a complaint about HMRC or about delays in them using information or them giving you misleading advice. You have to deal with that through the formal complaints procedure. You can't take a case into ADR that HMRC's criminal investigators are dealing with. Because they certainly don't want anything being said without prejudice. Everything to them is evidence and is on the record. You can't take debt recovery or payment issues. So, if they're refusing to grant you a time to pay arrangement or something like that, that isn't something that can be discussed in AGR. Default surcharges, AGR won't consider those. It won't consider any automatic late payments or late filing penalties. It won't consider pay-as-you-earn coding notices. It won't consider whether or not an extra statutory concession should be applied, because that's extra statutory. High income benefit charge, it won't consider pension liberation schemes, national minimum wage, because as we've said, that's not applicable to be litigated down the tax routes, civil evasion penalties or forfeiture. So, there are the things there where basically you're not going to get them accepted into ADR, but they're relatively few and far between, and most disputes you can go to ADR with. So, in terms of the meeting itself, as I say, compared to actually a lot of other HMRC meetings, but certainly compared to a tribunal hearing, it's pretty informal. So, the role of the mediator is to be very even-handed and to facilitate an open discussion between the two parties to see, if agreement can be reached. And sometimes we can reach agreement on some elements of a case, but not all elements of a case. And that of itself is helpful because that reduces, the elements of the case that do then have to proceed to tribunal. We've narrowed down the areas that are in dispute and quite possibly got rid of a bit of tax liability on the way as well. So initially what happens is both sides will have a pre-meeting with the mediator. They will explain their role and it gives us an opportunity to start to work on them. So, of course, we want them to be, even-handed and deal with both sides equally. But I always set out what I expect from HMRC on the other side. So I say, we're not here to refight past battles. we're here because we've got a situation and we want to see how we resolve it. So we're approaching this in a spirit of cooperation, and we want to work collaboratively with HMRC, to see if we can achieve that without having to go into a court. So what we ask in return is the same courtesy from HMRC. So we ask the mediator to make sure that HMRC do two things during the mediation. We want them to listen properly to what we're saying, and more importantly, we want them to be open to persuasion. They want them to be open to be persuaded by what we've said. So if they come in with a fixed view, they've already taken their decision, and it doesn't matter what we say, that's their decision. And I'll say we actually very rarely get that. It's not going to work. So, we hold the mediator to account to hold HMRC to account. So before we proceed to the actual mediation, we have opening statements. So each side produces a side of A4, which basically sets out their position. So what's in dispute and what they consider the position to be. And it's very high level. We're asked to keep it to one side of A4. So they're exchanged at the same time, usually about a week or two before the eventual meeting, to give the other side, the opportunity to consider them. And then we proceed to the meeting itself, which is usually a day. It's pretty informal, but it's basically an open discussion. So there is the main meeting room, and into that meeting room, whether it's online or in real life, will go the mediator, HMRC side and our side, but both sides also have a breakout room. So, as the discussions are ongoing during the day, the situation might change. So at any point, we can ask for some time to go and discuss with our client in our breakout room, and so can HMRC. So again, that's really useful. And at the end of it, there's a record of outcome, which both parties have to sign, and the outcome might be that it's failed, and that there's been no success whatsoever. The outcome might be that one side or another or the other have completely given way, and has accepted the other side's position. We get a lot of cases where that absolutely goes in our favour, because we've become very good at ADR, dare I say. And you get some where we just list out the matters that have been agreed in the ADR, and that's great. But we point out the points that still remain in dispute that can then continue on towards tribunal. However, one outcome that we're increasingly getting is that we agree to provide a certain amount of further information to HMRC, because we've used the ADR meeting to fully understand what they're seeing as the tax risks and why they're seeing it, but more importantly, to obtain their agreement with regards to what we are actually able to provide as evidence to satisfy them with regard to those risks. So again, the meeting has ended without a firm conclusion, but we have got a roadmap for how we can then persuade HMRC of our case. Now, on the one hand, I'd say, well, this just shows HMRC didn't investigate the case fully and properly before they took the decision. But if we've now got them to this position, and they're saying, well, okay, if you could provide that, and that, we think we'll be persuaded by that. Again, we can then win the case without going to a tribunal hearing. I'm just looking at the time, and we've been going for a while. So, okay, I'll do this bit. So in terms of the tribunal process, let's say a case is going to go to hearing. So obviously what we do is we make our application into tribunal, and we have to list our grounds of appeal. And then tribunal will accept the appeal, and they issue what are known as tribunal directions. And the tribunal directions is that they make an order of what must be done by the various parties, and deadlines are given for that work to be done. So the first thing is that within 60 days of tribunal accepting the appeal, HMRC have to produce their statement of case. Okay, this is really useful to us because this is an HMRC litigator at this point, so it's gone out of the hands of the caseworker, and the litigator is setting out precisely in writing what case they are going to argue in the tribunal hearing. And that's really useful for us, obviously, to see that. So a lot of the work we will then do will be based around knocking over various points within that statement of case. And by the way, we'll very often wait for that before we apply to tribunal for ADR, because that also, gives us a better insight into exactly what case HMRC are going to argue, so we can pull our counter arguments together ready for the ADR meeting. So that's the statement of case. Following that, a deadline is set for both parties to produce a list of documents. Now, these are all of the documents that you will be relying on in a hearing. So, it's all correspondence between HMRC and the taxpayer or their agents. It's copies of tax returns, it's copies of assessments, and all of that sort of thing. So both parties have to exchange those on the same day. And we can then go through theirs to see if there's any of the documents they're going to be relying on that aren't actually in our possession. And we can ask for them, and they have to provide us with copies, and vice versa. They can ask us for anything that we're wanting to throw in there that they haven't got. Witness statements. So a date is set by which both sides must produce their witness statements. Typically, most commonly, the witness statements will be one from the taxpayer and one from the HMRC caseworker. There may be witness statements from other people. It might be that we ask, the taxpayer's accountant to provide us with a witness statement, but typically, it's just one from each side. Excuse me. We then have to provide listing information. Now, what that is both sides have to give their opinion of how long the case will last, who will be attending from both sides, what dates to avoid for a hearing, which is usually going to be about 6 months down the line. So you have to say, what dates to avoid. So it's whether counsel has been appointed. Usually in the first year, the answer is no. But, if counsel's been appointed, we have to notify tribunal and the other side. Number of roll of the participants. Confirmation that everybody's able to attend the tribunal for a face-to-face hearing. How long is expected to last? Whether the judging panel needs reading time prior to the hearing, if so, how much? And then, as I said, the agreed periods of time of dates that you're not going to be available for. The hearing bundle. This is the big bundle of documents that will be used in the hearing. The judges will each have a copy. The relative representatives will each have a copy, and there'll be a copy in the witness box. And that's basically the combined two lists of documents. So, it's all of the correspondence, the assessments, and everything else. And there will also be what's known as an authorities bundle. And that is basically anything that isn't the correspondence, assessments, etc., relating to the substantive matter. So if either side are going to refer to specific tax cases, those tax cases have to be in the authorities bundle. Also, any extracts from HMRC manuals that either side wants to refer to, and so on and so forth. Now, the tribunal will make a direction on who should provide those bundles, and we always hope and pray that it will be HMRC. because they can be huge. The biggest one I've had, and it was the 10-day hearing in London I referred to, that was a VAT Kittel case. It was over 50 livre arch folders, and you have to provide a number of copies. So 2 copies for the judges panel, 2 for the respective representatives, and 1 for the witness box. That's a hell of a lot of livre arch folders. It's a hell of a lot of work. And HMRC have got far more resource to physically produce that and transport it than we have. So hopefully it's HMRC producing the bundles, not us. If the direction is made for us to do it, generally we can persuade HMRC's litigator that they'll do it instead. Skeleton arguments, again, there it's changed between the parties and 2 tribunals and to the tribunal, usually about a week before the hearing. And effectively, this is the precise case that you're going to argue in tribunal. It's almost a script, if you like, and then we proceed to the hearing itself. Can be anything between half a day and as long as you like. So how the hearing actually proceeds. So we're the appellant. We've made the appeal against HMRC's decision. So if it's me representing, it will be me up first. So my first job is to set out the matters that are actually in dispute for the tribunal and then present our case. And I will also call the taxpayer as our witness. I might not have any questions for them at all. I might just rely on what they put on the witness statement, but at that point they can then be cross-examined by HMRC's representative. Similarly, the respondents then go up, present their case, and they will call the caseworker as a witness. Again, they might not cross-examine the caseworker, but I can. And that's usually where you can have a whole lot of fun by trying to pull their witness statement to pieces. The judge can also examine and ask questions of the witnesses. At the end of that, both sides sum up their case, and then the judges retire to make their decision. Apart from the most simple cases, you rarely get a decision on the day. They usually take their time, and it can be months before you eventually get the decision. So it is in a courtroom setting, but most of them are in fairly modern buildings these days, and there are specific tax tribunal centres. So it's not as overbearing and intimidating as it probably was in past years, and it's not as formal as you might actually think. It's not as too bad at all. But what I'm now going to do is move on to the strategic use of it, really, because our hope from the beginning is that we're not going to have to go to a hearing in the first place. Okay, what we're hoping is we're going to use the tribunal listing as a strategy or a tactic to get what we want when the caseworker has proved difficult. So a starting point is to think about what different HMRC officers are targeted to do by HMRC. So a caseworker is quite simple, is quite straightforward, and it's why they can be such a problem. So basically, their targets usually in the investigating departments are to close a certain number of cases a year and to achieve a certain amount of financial yield from the cases they investigate. Now, in my days as a tax investigator, that second one didn't exist. There was no target for financial yield. But today, there certainly is. And if they tell you there isn't, they're not telling you the truth. They are judged on the amounts of money that they bring in from their investigations. So this is why they are so desperate to win their cases, because that could determine their next promotion or what have you. But the ADR mediator is very different indeed. So they're not interested in any yield. So what they are judged on when it comes to appraisals and promotions is the percentage of successful outcomes they achieve. in the mediation meetings they run. So, the last thing they want is for the ADR to finish in disarray with, both sides sniping each other and there's no agreement on anything. So I did say earlier on the pre-ADR meeting, we use that as an opportunity to persuade the mediator to properly hold HMRC to account and make sure they are listening and open to persuasion. And increasingly, in the last 2 or 3 years, we're finding that we don't really have to do that because they're doing it anyway. They've become really good at giving the HMRC caseworker a kick in when they need to do so. And they don't often do that in front of us. Usually, they'll take them off into HMRC's breakout room and they'll rip them a bit of a new one and say, look, you're not you're outside of the spirit of what this is supposed to be all about, and you're just dismissing everything the other side say, and I can see you're not thinking about it properly, so you need to sort yourself out. And very often the caseworker will come back in and will operate in quite a different way. So, the mediator not being interested in the amount of yield is brilliant. But also we've got the litigator. So, the whole point of listing it into tribunal is to get it out of the hands of the caseworker, really, and involve other people. And the litigator is an interesting one because HMRC are very happy to publicise that they win 80% of tribunal cases. And that is one of the most disingenuous things they ever say, because it's miles away from the truth. What they do is they win about 80% of all cases that actually go to a hearing. But we did a freedom of information request on this a couple of years ago. In terms of cases that are actually listed into a tribunal, because there are other advisors using it tactically like I do, they win quite a small minority. And really it's the ones that do proceed to hearings. Because what happens is the case is listed into tribunal. At that point, it's transferred to away from the caseworker into solicitor's office, and they then have to prepare their statements of case. And obviously, they're going to have to go in front of a tribunal judge and potentially embarrass themselves if the caseworkers not work the case properly or come to ridiculous decisions. So they don't want to go to hearing. The litigator doesn't, unless they know that they're going to maintain their 80% success rate. So if the case to them looks less than 50-50, they will seriously lean on the caseworker and look to withdraw from the case and accept the appeal at that point. And it's surprising how often that happens. And we've just had one actually last week where the caseworker had been prevaricating for 2 years, actually. He'd raised his assessments, he'd appealed the assessments, we'd listed it into tribunal with the intention of going to ADR, and then the litigator wrote to us withdrawing from the appeal. So we get the win immediately. So, good use of the litigator, and the litigator will always support us going into ADR as well. So we do need to bear these things in mind. What are different people incentivised by? The litigator couldn't care less whether it's £1 million of tax at stake or £10 of tax at stake. All they want to do is win the case. And if they don't think they're going to win the case, they won't want it to go to hearing. So, as I say, we frequently just make a tactical listing in with the hope and expectation that the litigator will withdraw from the case. And if they don't, then we've got a good chance of getting what we want at ADR anyway. So, it's very, very worthwhile to use. Now, the thing is, once you list it into tribunal, you can withdraw your appeal at any time. So, it might be that you go through, speaking with the litigator, which I'll very often do off the record to gauge their appetite and see if they've got the appetite to withdraw it and give us the win, or, ADR. And it's worth it because it's relatively inexpensive. And then, if we don't get what we want and the taxpayer really doesn't want to go to a hearing, then we can withdraw the appeal at that stage and not go to a hearing. So there is that flexibility there. I'm not going to go through that because I'm aware of the time. So just in conclusion, Tribunal and ADR are very useful parts of our toolkit, and increasingly ADR, especially when you've got a difficult caseworker, and we've all come across them. So we can use them to apply pressure on the caseworker, applying for a closure notice so that they have to reach a decision, or to move the case out of their hands and get a mediator involved, or a litigator. Really important to be aware of those respective agendas of different parts of HMRC. The caseworker isn't motivated in the way that the mediator or the litigator is motivated. And importantly, it can actually be far, far less costly than people think. From beginning to end, we can run a tribunal case to include ADR in the middle of it, for maybe £25,000. It's a fairly straightforward case, so it's not the huge amounts of money that people assume it's going to be. I'm well aware that I've overrun. Sorry about that. Nothing new there, but I hope it's been interesting, and I hope it's been a worthwhile hour of your time. If you have got any questions, as I have said, please do get in touch with your usual ETC contacts, and we'll be more than happy to discuss that with you. It doesn't hurt to ask or even to take a second opinion. So that's me done, and I'm going to hand over to Sarah now to wrap up. Enjoy the rest of your day, folks.
Thanks so much, Nick. That was amazing. We really appreciate your time. Yeah, as Nick's mentioned, if you do have any questions, drop us a line. You can contact us on comms@etctax.co.uk or enquiries@etctax.co.uk. Follow us on Eventbrite. Our next webinar is on inheritance tax. But yes, thank you very much, Nick, once again.
Thanks, folks.
Take care. Bye.